The laughter was a physical blow. It struck 9-year-old Caleb Reed and his mother, Emma, with the force of a wave, sharp and cold and cruel. In the packed gallery of Riverside County Courthouse, Department 7, people were openly pointing, hiding snickers behind their hands. "I will have order!" Judge Barrett's voice boomed, but there was a smirk playing on his lips. He was enjoying this. This court has indulged this spectacle long enough. Bailiff, remove the child from the defendant's table. Children do not practice law in my courtroom. The bailiff, a thick-necked man whose uniform strained at the seams, placed a heavy hand on his belt and took a deliberate, weary step toward the defense table. He was the physical instrument of the court's mockery. Caleb Reed stood on a battered leather briefcase, a thrift store find, just so his chin could clear the polished oak. He was swimming in a charcoal gray suit that must have belonged to a high school junior in 1985. The polyester sleeves were rolled up 5 times, revealing his thin brown wrists. The knot of his clip-on tie was the size of a small fist, buried beneath a collar wide enough to be a cape. Beside him, his mother, Emma Reed, was disintegrating. She was a paper-thin woman, worn down to a translucent fragility by 3 jobs and a lifetime of systemic gravity. Her hands, calloused and red, trembled so violently that the single sheet of paper she held, a 5-day eviction notice, vibrated. "Caleb, baby, sit down," she whispered, her voice a dry crackle of terror. "Please, baby, let's just go. We'll go. It's okay." To Emma, this was the end. The laughter confirmed her deepest fear, that they were a joke, that their pain was entertainment. Mr. Harris, their landlord, sat at the plaintiff's table, looking immaculate in a tailored blue suit. He whispered something to his lawyer, a slick man named Shaw, and they both shared a civilized, venomous chuckle. They had already won. The $50,000 summary judgment was a foregone conclusion. Judge Barrett, a man whose jowls shook with self-importance, raised his gavel to finalize the eviction and financially annihilate them. "For the last time, bailiff, remove him." The bailiff was 2 steps away. The laughter had quieted to a low, expectant murmur. The news cameras in the back zoomed in for the humiliating climax. Then, a voice cut through the heavy, wax-scented air. It was not a child's wail. It was a clear, cold chime of absolute certainty. "Your Honor?" The bailiff froze. The murmur died instantly. Judge Barrett's hand, holding the gavel, paused mid-air. Caleb Reed had not moved. His eyes, large and dark, were locked on the judge. "Your Honor, I would advise you to check your ruling." Barrett's face, typically a placid mask of judicial authority, began to mottle with purple. "You would advise me? You are a child. You have no standing. You have no voice in this court." He pointed a trembling finger. "You are in contempt. Bailiff—" "I do have standing," Caleb interrupted. His voice did not waver. It was not loud, but it was pitched to carry, an unnerving, adult-like cadence that silenced every breath in the room. Pursuant to the Federal Rules of Civil Procedure, Rule 17C, and the corresponding California State Code, a minor may sue or be sued in a civil action, provided they are represented by a guardian ad litem or— He paused, letting the words hang in the air. "A next friend." Caleb's small hand rested on a stack of documents on his briefcase. He pushed the top one forward. "I filed a motion 2 weeks ago to be recognized as next friend for the defendant, Emma Reed, who is my mother and current guardian." He looked up, his gaze sweeping over the stunned prosecution table, the now silent gallery, and landing, finally, back on the judge. "The court has not yet ruled on that motion. To remove me would be a violation of my mother's right to representation and a reversible error of procedure. You cannot proceed with the summary judgment until my motion is heard." The silence that followed was a vacuum. It was no longer the silence of mockery. It was the silence of profound, paradigm-shifting shock. The reporters in the back were scribbling furiously, their faces masks of disbelief. The bailiff, looking utterly confused, took a half-step back, his hand falling away from his belt. Mr. Shaw, Harris's lawyer, sputtered, "Your Honor, it's preposterous!" Judge Barrett stared at Caleb. He opened his mouth, but no sound came out. The color had drained from his face, replaced by a pale, mottled rage. The gavel, still frozen in his hand, had lost all its power. The entire authority of the courtroom, which seconds before had been his absolute domain, had just been hijacked by a 9-year-old in a clown suit. To understand how a child came to hold a gavel, a judge, and an entire legal system hostage with a single clause of civil procedure, one must rewind. One must leave the polished wood of the courthouse and go to the creeping, black damp of apartment 2B in the decaying lungs of the Maple Heights apartments. Maple Heights was a cruel misnomer. There were no maples, only a few dying, soot-covered elms choking on exhaust from the nearby I-215 freeway. There were no heights, only a sprawling 3-story monument to neglect, a stain of beige stucco and rust-colored railings. The air in the hallways smelled of mildew, stale cooking oil, and the metallic tang of desperation. In apartment 2B, the enemy was a living thing. It was a creeping, fractal map of Stachybotrys chartarum, toxic black mold. It had begun as a small colony in the damp, perpetually dark corner behind the toilet. In the 3 years they had lived there, it had staged a slow, successful invasion. It crawled behind the peeling, bubble-patterned wallpaper. It lived under the warped linoleum that squelched when stepped on. It bloomed in the dark of Caleb's own closet, painting his second-hand shoes with a grotesque greenish-black fur. Caleb's office was a small, particle-board desk wedged between the sofa and a rattling radiator that clanged like a warning bell. His side of the wall was not covered in posters of superheroes or sports cars. It was a chaotic, brilliant mural of yellow legal pad paper, sticky notes, and index cards, all connected by a web of red ink arrows. Res ipsa loquitur. The thing speaks for itself. Breach of implied warranty of habitability. Calar Sevish. Code. Paragraph 1941. 1. Estoppel. A principle of justice and equity. Negligence per se. Caleb was a prodigy, but not in the sterile, celebrated way of violin concertos or national spelling bees. His genius was a practical, desperate thing, forged in the fires of necessity. While other kids his age were learning multiplication, Caleb was at the Riverside Public Library, cross-referencing state housing law with federal statutes. His primary textbooks were a dumpster-dived Black's Law Dictionary, 7th edition, and a stack of California civil procedure outlines discarded by a local community college. He studied the law not as an abstract, noble concept to be debated by men in robes. He studied it as a system of rules, an if-then statement, a complex code. And he sensed, with the profound intuition of a genius, that the system his landlord was using to crush them was full of bugs. His mother, Emma Reed, was the why. She was a ghost in her own life, working 3 jobs just to keep them in this toxic box. A 5 a.m. shift cleaning offices downtown, a midday shift as a hospital cafeteria server at Riverside Community Hospital, and a night shift stocking shelves at a 24-hour convenience store. She came home in fleeting, exhausted bursts, her face gray with fatigue, the smell of industrial bleach or day-old coffee clinging to her uniform. Caleb would be waiting for her, a cup of weak tea in one hand and a law book in the other. He would read to her as she soaked her swollen feet in a plastic tub of hot water and Epsom salts. Not Good Night Moon. He read her the finer points of tenant rights. "It says here, Mama," he'd explain one night, his small brow furrowed, "that a landlord must maintain the premises in a condition fit for human occupation. This is not fit. The mold, the radiator, the window that doesn't lock, that's a breach." Emma would just nod, her eyes closed, too tired to even hope. "It's okay, baby. We just keep our heads down. Just 2 more paychecks. We'll save up for a new deposit." Their antagonist was Mr. Harris, a man who moved through Maple Heights with a too-white smile and the cold click of an expensive pen. He was the physical embodiment of Harris Realty Group, a corporation that specialized in buying low-income properties, sucking them dry of rent and federal subsidies, and performing exactly 0 maintenance. His visits were not for inspection. They were for intimidation, always arriving on the 2nd of the month to remind tenants that the 1st was past. The inciting incident arrived not with a bang, but with the wet, quiet slap of a manila envelope being slid under their door. It wasn't a late notice. It was a summons. Emma's hands shook so hard she couldn't open it. Caleb had to tear the flap. Harris Realty Group was suing Emma Reed. This can't be right," Emma whispered, her eyes scanning the dense, terrifying text. Caleb took the papers from her. His eyes, usually so bright and curious, narrowed into cold slits. He's suing us for the mold. He's saying we caused it," Emma said, a hysterical, choked laugh bubbling in her throat. "He's claiming our lifestyle led to excessive moisture. He's saying we're unclean." Caleb's eyes scanned the legal filing. The number jumped out at him. $50,000. It wasn't a random number. Caleb knew from a contractor's ad he'd seen that this was the high-end estimate for a full mold remediation, new drywall, new plumbing, and new flooring for an apartment their size. It was a checkmate. Harris wasn't just evicting them. He was trying to force them to pay for the repairs he had neglected for a decade. A working poor, single mother could never fight it. She would be forced to settle, to have her wages garnished for the rest of her life, to be branded with an eviction and a judgment that would make it impossible to rent a shed, let alone an apartment. Emma collapsed onto the threadbare sofa, the one with the broken spring. The fight finally, utterly, drained out of her. "We're done, Caleb. We're done." He won. Caleb stared at the summons. He looked at the black mold creeping out from behind the radiator, a living, victorious entity. He looked at his mother, who was silently weeping, her body curled into a ball of defeat. A cold, unfamiliar anger settled in his chest, a precise, analytical rage. This wasn't just an injustice. It was a sloppy, arrogant, legally flawed maneuver. Harris had overplayed his hand. "No, Mama," Caleb said, his voice quiet. He walked over to his wall of notes, took down a card defining tortious conduct, and pinned the summons in its place. "He's wrong. He's wrong in the law. He wasn't just fighting a lawsuit. He was fighting the thing that was poisoning his mother, the thing that was killing her spirit before the mold even had a chance to kill her body." The next few days were a blur of escalating despair for Emma. She called legal aid, only to be told the wait list for a housing lawyer was 6 months. She called a pro bono lawyer from a bus stop ad, who laughed when he heard the $50,000 figure and told her to just settle for $30,000 and get out. "We'll pay him, baby," she told Caleb one night, her voice hollow as she counted out her tip money on the kitchen table. $7.42. We'll find a way. I'll ask for more shifts at the hospital. Maybe I can clean on weekends, too." Caleb looked up from the floor, where he was surrounded by a fortress of library books. "Pay him for what, Mama? For his own negligence? That's not the law." "It doesn't matter what the law is, Caleb." Her voice broke, sharp and brittle. "It matters who the judge believes. They won't believe us. Look at us. Look at this place." "They will if we have the evidence," Caleb said. He stood up, his small form vibrating with a new, steel-cord resolve. He tapped the summons pinned to his wall. "We won't hire a lawyer. We'll become one." Emma stared at him, her heart shattering. "You're 9 years old, baby! This isn't a game!" "This isn't a game," he agreed, his eyes unblinking. "It's a motion to dismiss." And so the montage began. But it wasn't a montage of inspiring music and quick cuts. It was a slow, grueling march. While Emma worked, Caleb fought. He became a ghost in the stacks of the Riverside County Law Library, a place that smelled of old paper, dust, and lemon polish. The librarians, at first suspicious of the small, serious black child reading Case Law Reporter, soon became his silent allies. They saw the intensity, the methodical way he took notes. They started leaving stacks of relevant books on his table before he even arrived. He devoured civil procedure. He learned about motions, about discovery, about subpoena duces tecum. He learned about standing, about pro se representation. He mapped the entire case on his wall. Harris's claim, fraudulent; their defense, breach of habitability; his counterclaim, negligence, infliction of emotional distress. And then, in a dusty copy of Federal Practice and Procedure, Volume 6, he found it. Rule 17. Next friend. A key forged in ancient English common law, designed for this exact purpose, to give a voice to the voiceless, to allow someone to speak for a minor, an infant, or an incompetent person. He looked up. Incompetent. The legal definition wasn't about intelligence. It was about one's ability to cope with the exigencies of litigation. His mother, working 20-hour days, trembling, defeated, and suffering from what the clinic called chronic hypertension, was legally incompetent to defend herself. He could be her voice. He spent 3 nights writing the motion. He used a library computer, mimicking the arcane, stilted language he had memorized. Comes now Caleb Reed, a minor, appearing as next friend for the defendant, Emma Reed. He listed the reasons, calmly and clinically: his mother's physical and mental exhaustion, her inability to cope with the legal stress, her work hours preventing her from obtaining counsel, and his own intimate and complete knowledge of the facts of the case. He printed 3 copies at the library, using quarters his mother had left for laundry. The next day, his mother collapsed. It happened at the hospital cafeteria. 1 minute she was handing a doctor a tray of Jell-O. The next, she was a pile of blue scrubs on the gray linoleum. Caleb found himself in the emergency room, sitting on a hard plastic chair, his small legs dangling, as a tired resident in green scrubs knelt before him. "Caleb, your mother she's suffering from extreme exhaustion and a hypertensive crisis. Her blood pressure is dangerously high. The stress, it's just too much for her body. She has to rest, no work, no stress, or she won't recover. Do you understand?" That was it. The abstract fight became concrete. The lawsuit was no longer about a $50,000 judgment. It was about his mother's life. The next morning, Tuesday, November 5th, Caleb Reed put on his father's old clip-on tie, tucked his motion into his backpack, and took the number 16 bus downtown. He walked, small and resolute, into the soaring, marble-floored lobby of the Riverside County Courthouse. He followed the signs to the civil filing window. The clerk, a woman with a magnificent beehive hairdo and a nameplate that read Martha, didn't even look up from her crossword puzzle. Next, Caleb slid the papers, pristine in their manila folder, under the glass. "I need to file this in Harris Realty Group vs. Reed, case number 88C1024. Martha looked at the paper, then at him. "This is a joke, right?" "Where are your parents, sweetie?" "My mother is the defendant," Caleb said, his voice clear and flat. "I am filing a motion to appear as next friend." The clerk laughed. A short, sharp, ugly sound. "Honey, children don't file motions. You need a lawyer for this. Go on now." Is it the court's official position to deny a filing based on the filer's age? Caleb asked, his voice polite but firm. Because if so, I'd like a written statement of that denial for my appeal. Please, the case number is on the motion. Martha's smile vanished. She saw the deadly seriousness in his eyes. She looked at the motion. It was formatted correctly. The case number was right. The caption was perfect. It was, technically, a legal document. She had no legal grounds to refuse it. With a look of pure venom, she picked up her heavy, ink-soaked stamp. Chunk, chunk! She stamped all 3 copies. Filed NOV 5, 2023, Riverside County Clerk. She thrust them back at him. You're wasting your time, kid. Caleb took his copy. Thank you. You are required to serve 1 copy to the judge's chambers and 1 to the plaintiff's counsel, listed on page 3. He turned and walked out, the heavy stamp on his motion feeling like the first legal recognition of his fight. He had entered the system. The game was on. The filing of the motion was like a small pebble tossed into the stagnant, scummy pond of Maple Heights. The ripples spread slowly, then all at once. Word got out. Emma Reed's little boy, the quiet one, the one who reads, he's fighting Harris in court. At first it was just whispers in the hallways, by the rattling washing machines in the basement. Then, the offerings began. It was a pilgrimage of the dispossessed, coming to the door of 2B. Mrs. Rodriguez from 3B, a tiny woman with 7 children and eyes perpetually wide with worry, slipped a folded piece of paper under his door. It was a photo of a cavernous crack in her ceiling, a stalactite of rust and asbestos-laced pipe leaking brown water onto her baby's crib. The photo was time-stamped, 2018. Mr. Abebe from 5A, a quiet, dignified Ethiopian man who worked as a night-shift taxi driver, stopped Caleb by the mailboxes. He wordlessly handed over a thick stack of letters. They were all certified mail, all addressed to Harris Realty Group, all of them detailing the complete lack of heat in his apartment for 2 consecutive winters. Each one had a received signature. None had a reply. The community, long atomized by fear of eviction, of retaliation, of ICE, began to awaken. Caleb's apartment, with its wall of notes, became a repository for the building's collective pain. He received unpaid repair requests, photos of rat infestations, copies of letters from Harris threatening tenants with eviction for complaining to the city. Caleb wasn't just building a defense, he was building a class action lawsuit in miniature. He was no longer just a defendant. He was the defendant, but he needed his smoking gun. He knew Harris and his lawyer Shaw would claim the mold in 2B was new, that it was their fault. He had to prove, unequivocally, that Harris knew. He went back to the city. Not the library. The Riverside County Records Office, a dusty basement full of beige, coffin-like filing cabinets. He told the clerk he was doing a school project on the history of his building. The clerk, bored, waved him in. For 3 days, he sifted through property records, tax assessments, and utility filings. The air was thick with the smell of old paper and dust. And then he found it. It was misfiled under utility easements, not code violations. An inspection report filed by a city inspector 2 years prior, before they had even moved in. The inspector had been called out for a possible code violation by the previous tenant of 2B, a tenant who had been evicted, Caleb noted, for non-payment 2 weeks after the complaint. Caleb's hands shook as he read the report. His heart was a drum in his chest. Extensive pre-existing water damage noted in Unit 2B, drywall saturation levels at 90%, visible sporulation of Stachybotri's chartarum, recommended immediate and total remediation before unit can be reoccupied. It was all there. Harris hadn't just known about the mold, he had been officially cited for it. He had covered it up with a cheap coat of Kilt's paint, leased it to his mother, and was now suing her for the very damage the city had ordered him to fix. This, Caleb knew, was per se negligence. It was fraud. It was a crime, but he didn't stop. His mind was on a different track. Why would a landlord be so bold? Why would he file a $50,000 lawsuit he knew was fraudulent? He must have been sure he would win. He must have known the judge. He went back to the library. He looked up Harris Realty Group's corporate filings. He saw the board members. He looked up the public disclosures for the judge assigned to their case. Judge Harold Harry Barrett. It wasn't a direct link. It was smarter, more insulated than that. Caleb found a Riverside Pension Fund, LLC, that was listed on Judge Barrett's public financial disclosures. It was a blind trust, but its holdings weren't entirely blind. He then found that the same LLC was a primary shareholder in a larger holding company, Inland Empire Property Holdings, which, 3 levels down, was the sole owner of Harris Realty Group. Judge Barrett and Mr. Harris didn't just know each other, they were partners. Barrett's retirement was being funded by the exploitation of tenants like his mother. Every eviction he rubber-stamped, every complaint he dismissed, put money in his own pocket. The rumors started to fly. A kid lawyer was digging up dirt. Reporters, smelling a much bigger story than a simple eviction, started circling. When the date for the preliminary hearing on the eviction arrived, Caleb packed his briefcase. He had the inspection report, the stack of tenant complaints, and the LLC filings. He was no longer a 9-year-old boy in an oversized suit. He was a gladiator, armed to the teeth, and he was walking into the Coliseum. The scene was pure chaos. The moment Judge Barrett took the bench, the media scrum in the back surged, cameras flashing. The gallery was overflowing. Mr. Harris was at the plaintiff's table, whispering angrily to his lawyer, Mr. Shaw. He looked annoyed, as if this whole thing was a procedural hiccup delaying his victory. This was the moment, the opening scene. Barrett slammed his gavel. "Order!" He fixed his glare on Caleb, the boy who had dared to file a motion. "Bailiff, remove the child." And this was the moment Caleb, standing on his briefcase, cited Federal Rule of Civil Procedure 17. The courtroom fell into that stunned, electric silence. Judge Barrett, his face a mask of pale rage, slowly lowered his gavel. He had been ambushed. He was on the record. The press was here. He couldn't just ignore a correctly cited federal rule in front of a dozen reporters. "The motion is noted," Barrett stammered, his voice tight. "And it is denied. This is a courtroom, not a daycare. Children do not practice law." "Then I'll just have to practice it as a witness," Caleb said calmly. Mr. Shaw, Harris's lawyer, shot to his feet. "Your Honor, this is preposterous. The boy he's a child. He cannot possibly understand the ramifications of his testimony or the proceedings." Caleb turned his gaze on him. "Mr. Shaw, are you currently under oath?" Shaw blinked. "What? No, I'm addressing the court." "Then I'd ask that you refrain from offering testimony about my mental state, which you are not qualified to give and cannot be cross-examined on," Caleb said. A ripple of shock went through the gallery. The lawyers present grinned. The kid was sharp. "Enough!" Barrett roared, his authority slipping. He was visibly sweating now. "The motion for next friend is denied. This is a simple eviction hearing. I am granting the plaintiff's motion for summary judgment in the amount of $50,000. "You can't," Caleb said. "I beg your pardon?" Caleb pushed the county inspection report onto the table, his small hand flat on it. "You can't. A summary judgment is only granted when there are no disputed issues of material fact. I have here a certified county inspection report, dated before my mother's lease, proving the mold and water damage were pre-existing. This is a disputed fact." He then held up the thick stack of photos and letters from the other tenants. "And I have proof of a building-wide pattern of negligence and retaliatory behavior. This is not a simple eviction, Your Honor. This is a case of systemic fraud." Shaw was on his feet again. "Objection. Improperly submitted. That's discovery. It's not admissible in a preliminary hearing." It's a preliminary hearing on a fraudulent eviction, Your Honor, Caleb countered, his voice ringing out. This evidence is not just material, it's dispositive. It proves the plaintiff's case is a fabrication. Judge Barrett looked at the report. He looked at the cameras. He was trapped. If he accepted the report, the $50,000 claim was dead, and Harris's fraud was on the record. If he refused to accept a certified county document, it would be blatant, appealable misconduct, and the reporters would have a field day. "The court," Barrett said, his voice straining, "will not accept this. It is procedurally unsound." Caleb took a deep breath. This was the moment. The point of no return. Is that because the court has a vested financial interest in Harris Realty Group, LLC? The explosion was not a sound. It was a sudden, collective gasp, a vacuum that sucked all the air from the room. You could have heard a pin drop on the thick carpet. Mr. Harris went white as a sheet. Mr. Shaw's mouth hung open, his objection forgotten. Judge Barrett's face went from purple to a terrifying ashen gray. "You are in contempt of court. I will have you removed and sanctioned." "Am I?" Caleb asked, his voice still terrifyingly calm. "Or am I petitioning the court for recusal? I formally request Judge Barrett's recusal from this case, pursuant to 28 U.S. Code Section 455, on the grounds of judicial misconduct and direct financial conflict of interest." He didn't yell, he didn't accuse, he stated a fact. Judge Harold Barrett is a listed partner in the Riverside Pension Fund, LLC, which is the primary shareholder of Inland Empire Property Holdings, the parent company of the plaintiff's corporation. He walked, with all the dignity his 9-year-old suit-draped body could muster, to the clerk's desk, right past the stunned bailiff. He laid down the LLC filings and the printout of Barrett's own public financial disclosure, which he had highlighted in yellow. "The evidence is on the record." Judge Barrett looked at the documents. He looked at the press, who were now in a full-blown frenzy, flashing pictures of the documents, of Caleb, of the judge himself. He was exposed. He was ruined. He stood up so fast his heavy oak chair shrieked backward and slammed into the wall. He didn't slam the gavel. He threw it. It clattered uselessly against the seal of the state of California. "Recess! Recess!" he bellowed, and fled the bench, his black robe flapping behind him like the wings of a wounded crow. Within an hour, the Chief Justice of the county had removed Barrett from the case. By the end of the day, the Judicial Commission of California and the U.S. Attorney's Office had both opened formal investigations. The following week, the atmosphere in Department 7 was unrecognizable. The circus was gone. The buzzing, frantic energy of a media spectacle had been replaced by the heavy, solemn, almost sacred air of actual justice. The gallery was still packed, but this time it was filled with quiet, hopeful tenants from Maple Heights and half a dozen other buildings. The new presiding judge was Judge Althea Monroe. She was a tall, uncompromising black woman who wore her natural hair in a crown of silver-black locks. She was known for two things: her encyclopedic knowledge of the law and her absolute zero-tolerance policy for bias, corruption, or procedural games. Her stare did not contain contempt. It contained expectation. She took the bench, her movements economical and precise. She looked at the file, then at Caleb, who was standing on his briefcase. "Mr. Reed," she said, her voice crisp and clear, "I have reviewed your motion to appear as next friend. It is well argued, legally sound, and given the circumstances entirely necessary. Motion granted." Emma, sitting in the row behind him, let out a sound that was half sob, half gasp. Mrs. Rodriguez reached over and grabbed her hand. "The plaintiff's motion for summary judgment is denied," Judge Monroe continued, her gaze shifting to a pale and shaken Mr. Shaw. "As is the eviction. We will proceed on the defendant's counterclaim for negligence, breach of habitability, and infliction of emotional distress. Mr. Reed, you may proceed." The tone shift was seismic. This was a space for truth. Caleb, now officially recognized as counsel, was no longer a boy in a suit. He was an officer of the court. He stood, and for the next 2 hours, he laid out his case. He did not use emotion. He did not raise his voice. He used facts. He was a surgeon. He presented an enlarged timeline chart showing the date of the county inspection, the date his mother signed the lease, and the date of the first unanswered repair request. He presented the insurance claims Mr. Harris had filed and been paid for water damage, which was never fixed. He presented the hundreds of tenant complaints, stacked neatly in bankers' boxes, showing a clear, undeniable pattern of racketeering. Judge Monroe watched, her face impassive, as Caleb built his case, brick by brick, into an unassailable fortress of truth. Mr. Shaw's objections grew weaker and weaker until he finally sat, defeated, his head in his hands. Then Caleb did what he'd been waiting to do. The defense calls Mr. Harris to the stand. Harris, looking thin and green, took the stand. He was no longer the smiling, confident predator. He was prey. Caleb approached the stand. Mr. Harris, is this your signature on this 2018 repair request from Mrs. Rodriguez in 3B, complaining of a leaking pipe? Harris looked at it. I don't recall. Is this your signature on the 2019 county inspection report, acknowledging the presence of Stachybotrys chartarum in apartment 2B? I don't recall. Is this your signature on the eviction notice you sent her after she complained? And the one you sent Mr. Abebe after he complained about the heat? And the one you sent the tenant in 4D after they complained about the rats? Harris was sweating, wiping his forehead with a silk handkerchief. My property manager handles those. Caleb stepped back. Mr. Harris, did you or did you not knowingly and repeatedly lease apartments you knew to be condemned while simultaneously threatening tenants who complained about the conditions? Shaw shot up. Objection. Compound question. Badgering. Overruled, Judge Monroe said, her eyes fixed on Harris. He will answer the question. Harris looked from his lawyer to the judge, and finally to the 9-year-old boy staring at him, not with hatred but with a terrifying, cold certainty. Harris swallowed. On the advice of counsel, I invoke my Fifth Amendment right against self-incrimination. The gallery gasped. It was an admission of guilt. Caleb nodded, his work done. He turned to Judge Monroe. Judge Monroe's face was granite. Given the extensive documented evidence of a pattern of negligence, fraud, and potential racketeering, and given Mr. Harris's testimony, this court orders a full federal investigation into the business practices of Harris Realty Group, effective immediately. The fight for apartment 2B was over. The war had just begun. Harris's empire was built on fear, and now he was the one who was afraid. A cornered animal is a dangerous one. As the federal investigation, triggered by Judge Monroe's order, began seizing his bank accounts and raiding his offices, he lashed out. The smear campaign was swift and brutal. Talk shows and cable news pundits, funded by anonymous concerned citizen groups, which Caleb easily traced back to Harris-owned shell companies, began to question the narrative. Is this kid lawyer for real? Or is he a prop? One pundit with a perfect blonde helmet sneered. Is he being coached, manipulated by activist groups who are using this poor child as a puppet? Another, a family values advocate, questioned Emma's fitness as a mother. What kind of parent would subject their 9-year-old child to this kind of stress, this legal circus? It's child abuse, plain and simple. Where is Child Protective Services? This, more than the laughter in the courtroom, hurt Caleb. He saw his mother reading the comments on a local news article, her face crumbling. CPS did visit, a tired-looking woman who took one look at Caleb's wall of legal notes, his organized files, and his mother's obvious devotion, and closed the case an hour later, wishing them luck. But the fear was real. Then the danger grew personal. They came home one night from the library. Emma was feeling stronger, and she'd been helping Caleb organize the tenant files. They walked down the dim, mildewed hallway to 2B and stopped. There was a note, not slid under the door, but nailed to it with a 6-inch pocket knife. The knife's blade was plunged deep into the wood, quivering. Emma dropped her keys, her hands flying to her mouth. Caleb read the note. It was written in a rushed, angry scrawl. "Stop now or lose everything. This isn't a game. Last warning." Emma let out a small, terrified sound. "Caleb, baby, we won. We're safe." The judge stopped the eviction. "Let it go, please. This is different. He's dangerous." Caleb pulled the note off the door. He looked at it, his expression unreadable. Then he wiggled the knife out of the wood. He examined it. It was cheap, with a plastic handle. He looked at his mother, her terror a tangible thing in the dim hallway. "He's scared, Mama," Caleb said, his voice soft but steady. "He's not thinking. He's desperate. Scared people make mistakes. This is a mistake." He opened his backpack and pulled out a plastic baggie, one he usually kept his pencils in. He carefully placed the note and the knife inside. "What are you doing?" Emma whispered. "This is Exhibit 26, Mama. Witness intimidation. It's another felony." But the threat had an unintended, powerful consequence. The community, which had been watching from the sidelines, now saw one of their own being directly threatened. The fear, which had held them paralyzed for so long, finally broke and turned into a white-hot collective rage. The public uprising was immediate. Protesters, led by Mrs. Rodriguez and Mr. Abebe, began to picket outside the courthouse and then outside Harris's gated community home in the suburbs. "Justice for tenants," they chanted. "Barrett and Harris court corruption." The local story went national. The kid lawyer of Riverside was no longer a sideshow. He was now a symbol of a nationwide fight for housing justice. Judge Barrett, facing a federal inquiry and public disgrace, was suspended indefinitely by the California Commission on Judicial Performance. His career was over. The final hearing wasn't about the eviction. That was long gone. This was about the $50,000 civil suit Harris had originally filed against them. Harris, in his arrogance, had never withdrawn it. Now Caleb was using it as a vehicle to end him. The courtroom was a zoo. National media. Law students from USC and UCLA had driven hours to be there, and the entire overflowing population of Maple Heights, who had taken the day off work, filling the gallery and the hallway outside. Judge Monroe called the court to order. "Mr. Reed, this is your counterclaim. The floor is yours." Caleb stood. Harris was there, looking thin and green, surrounded by a new, more expensive team of criminal defense lawyers. "Your Honor," Caleb began, "Mr. Harris sued my mother for $50,000 for damages he claims she caused. I have already proven these damages were pre-existing. I have proven his negligence. But the truth is worse." He walked to the bailiff and handed him a document. "I submit Exhibit 27. This," Caleb announced to the court, "is an insurance claim filed by Harris Realty in 2019, after the city inspection and before we moved in. It is for $75,000 for catastrophic water and mold damage to apartment 2B. A murmur went through the crowd. "But he wasn't done," Caleb continued, his voice rising, clear and strong. "This is another claim. From 2020, for the same apartment, for $60,000, for the same mold." Caleb turned to the jury box, though there was no jury. He was speaking to the world. Mr. Harris wasn't just neglecting the damage. He was profiting from it. He collected $135,000 from his insurance company for repairs he never made. He covered the poison with cheap paint, leased the apartment to my mother, and when she complained, he sued her for $50,000 for the very same damage he'd already been paid for. Twice. He turned to Harris. "It's wire fraud. It's mail fraud. It's insurance fraud. It's racketeering." Harris's new lawyer was on his feet. "Objection! Objection! This is a civil hearing. These are criminal allegations." "This is a crime, Your Honor," Caleb said simply. "A crime he tried to cover up by abusing the court system." He looked at Mr. Harris, who was visibly shaking, his face slick with sweat. "Mr. Harris, did you commit insurance fraud?" Harris's lawyer screamed, "Do not answer that!" Harris looked at the judge, at Caleb, at the sea of angry tenants. He stammered, I, Fifth Amendment. It was over. Caleb turned to the gallery, to his mother, who was watching him with tears streaming down her face. He spoke, and his voice was clear and strong. "My mother told me to be quiet. She said we were too small, that the world was too big. But I learned that losing quietly just helps bad people win loudly." Judge Monroe looked at the evidence. She looked at Harris. Her expression was one of cold, righteous fury. This court finds for the defendant, Emma Reed, in the full amount of her counterclaim for pain and suffering. Furthermore, this court refers this case, and Mr. Harris, to the United States Attorney's Office for immediate prosecution on multiple counts of fraud, witness intimidation, and racketeering. A roar erupted. People were cheering, crying, hugging. Emma ran to the defendant's table and wrapped her arms around her son, lifting him clean off his briefcase. The consequences were swift and total. Judge Barrett resigned in disgrace and was disbarred. Harris Realty Group was dismantled by federal receivers. Its assets were seized, and a new fund was established. The Maple Heights apartments were turned over to a tenant cooperative. Mr. Harris pled guilty and was sentenced to 12 years in federal prison. The day of the sentencing, Emma and Caleb walked out of the courthouse. The cameras were there, but they weren't mocking. The crowds were there, but they weren't laughing. They were chanting, "Caleb, Caleb, Caleb!" Emma held his hand, her face no longer gray with exhaustion, but bright with a pride so fierce it was almost painful. "You did it, baby," she whispered. "You saved us all." Caleb leaned his head against her side, suddenly, for the first time in a year, feeling every bit his 9 years. "No, Mama," he said. "We did it." The case of Reed versus Harris Realty became a landmark in housing justice law. The old Maple Heights apartments, now owned by the tenants, was fully remediated and renamed the Reed Residences. Emma Reed went to school, got her paralegal certificate, and now heads the Reed Legal Advocacy Center. And Caleb, at 16, became the youngest student accepted to Harvard Law School in its history. Years later, Professor Caleb Reed stood at a podium and said, "Power doesn't live in money or titles. It lives in courage. It lives in people who refuse to stay quiet. Because even a child can shake the walls of a courthouse if the truth is loud enough." The story of Caleb Reed is a powerful testament to the fact that knowledge is power, and courage can come from the most unexpected places. A 9-year-old boy, armed with nothing but the truth and a thrift store suit, faced down a corrupt system and won. He didn't just save his mom, he changed the law, dismantled a criminal enterprise, and gave a voice back to an entire community. His legacy proves that no one is too small to demand justice. If you were inspired by Caleb's incredible story, click the subscribe button and ring the bell so you never miss a video. Share this with everyone you know who needs a reminder that one person can make a difference.